Hi, in today's video I thought I would talk a bit about patenting, and specifically if you have an invention, what part of it should you patent? So this is assuming that you've come to the conclusion that you've got a novel idea that has commercial value and it's worth seeking intellectual property law protection of that idea so that you or your company have a competitive advantage over other companies that didn't come up with the idea. That's the whole idea behind intellectual property and patents. And one of the issues that you find as an inventor is that you have this great novel idea that you think is really valuable, and it has lots of applications in lots of different areas. And so when you start drafting your patent, you find that once you've captured the essential elements of that core idea, there are then lots of use cases, lots of other ways that it can be implemented, lots of different variants for the idea, and most commonly, lots of different things that it can be attached to. And so the patent drafting exercise can quickly expand from being a novella into a 10-part series, the likes of which someone like Brandon Sanderson would write. And of course, if you're a startup or if you're a lone inventor, you're looking at a huge amount of work to draft a patent application document that covers all these things. So, as is always the case in life, there has to be a compromise. If you have this novel idea, you do need to make sure that the core idea is well covered in your patent application document so that you have the claim to that invention and other people and other companies don't. Then it's really a matter of how much time do you have to spend on covering all the material around it to ensure that you have as full protection as possible. And patent attorneys, if you ask them, will of course recommend that you keep writing more and keep writing more because they are paid by the hour. You as an inventor or your startup company, unfortunately, will probably not have the money, and certainly there won't be the time to make sure that all these things are covered. So really it's a matter of looking at the core idea, making sure you have that as fully covered as you can, and then with whatever spare time and money you have left, you cover all the stuff around it. And the analogy I use is, imagine that you've invented the petrol engine. It's a very versatile invention. You can use a petrol engine to power a car or a lawnmower or a helicopter or a submarine maybe, or a boat. There's lots and lots of applications. So there you would have the problem that writing your patent, you could spend hundreds and thousands or hundreds of thousands of pages describing all the different uses for this core invention. So what do? Well, you make sure that you have covered the core thing, the engine, and then if you have time, you describe how it could be used in a car or in a lawnmower or in a boat or something like that. And if you haven't got time, well, at some point you have to draw a line under it and say, that's it. You guys get the idea. And the point here is that provided you've covered the core concept, in this analogy, the engine, then anybody who goes and builds a helicopter or a hovercraft or something using your engine will still either have to agree licensing terms with you or be infringing and risk being sued for infringement because they've used that core invention. And the fact that you didn't specifically describe that it can be used in a hovercraft, well, it's a shame, but because there are thousands of inventions that use engines at their core, you can't expect to cover them all. And so that gives you an idea of where the compromise is to be drawn. I hope you found this interesting and useful, and I'll see you in the next video soon. Bye for now.